Welcome to Innovations and Breakthroughs with your host, Rich Goldstein, talking about the evolutionary, the revolutionary, the inspiration and the perspiration, and those aha moments that change everything. And now, here's your host, Rich Goldstein.
Welcome to Innovations and Breakthroughs, where I feature top leaders and the path they took to create change. I'm Rich Goldstein, and past guests include Steve Simonson, Ryan Dice, and Roland Frazier. This episode is brought to you by my company, Goldstein Patent Law, where we help you to protect your ideas and products. And if you'd like to find out more about how to protect your idea, go to goldsteinpatentlaw.com, where there are amazing free resources for learning about the patent process. And you could also check out the book that I wrote that explains in plain English how patents work. It's called the ABA Consumer Guide to Obtaining a Patent. And so this is a special episode that I'm doing along with the fellows from Managed by Stats. I have with me here today Curtis Johnson and Danan Coleman. And we're going to have a conversation that's going to be mostly guided by them to talk about IP, which is an important topic for our podcast. But I'm going to turn it over to them, and then we're going to have a great conversation.
Basically, in order to get enhanced brand content and to get all the stuff that goes with that, you need to get a trademark, and then Amazon grants you everything that you want, right?
Right. So basically, what you're referring to is brand registry.
Yes.
So brand registry is something that you want, and there's really two aspects to it. Is once you get brand registry, you get the enhanced content and those advanced tools, and then there's also the aspect where you can protect that brand and you could prevent other people from using that brand on Amazon.
Yes.
So that's brand registry, and so in order to get brand registry, you need to have a registered trademark.
Right. Yes. So having recognized that, I went down the path of doing it myself.
I know this story, so I know where this is going.
Curtis has been there for the whole thing. Yeah. So, first of all, I don't like going through law because I don't particularly care for the language of Latin, which is what law is written in, essentially. Correct me if I'm wrong, but the Latin words themselves together mean something else than alone. And it took me a little bit to figure that out, and the problems that I went through was that I went, Danan Enterprises Incorporated. Nobody's got that name but me, right? So I thought, $400, I'll do it myself. Nobody's going to have my name. Well, I got denied, and then I went, because it's a surname, and Enterprises is generic, and Incorporated is generic, so I couldn't trademark those. And so I went, but wait, I have... what is it when you have been using a term for 5 years? I've forgotten the term. Claimed
distinctiveness. Acquired distinctiveness.
Acquired distinctiveness. Yes. So, but I have that, and then it was denied again. And these are like, hey, there's an office action. Check it out. We'll wait for your response. Then I had to put in a signed affidavit that I would not claim that I had ownership over Enterprises Incorporated, and that it was
you didn't sign that, did you?
I did.
No, I'm just kidding.
Great, thanks a lot.
Oh God, what did I do?
My immediate thing was like, well, whatever choice did I have?
Wait, you're like, that was the right thing to do, right?
Was it the right thing to do?
I think yes, it was.
Oh, good, okay.
No, the right thing to do was for me to utilize my advanced knowledge to break your chops that. That was the right thing to do.
Yes, that was the right thing to do. Basically, after that, they went, okay, cool, we're going to publish you in the paper and see if anybody claims that I can't use that, right? These are all things that you should know about learning from him and not me, by the way, or the website, or the Tease videos, which actually aren't that bad, but Tease is T-E-A-S. Then I got denied again.
Tease videos are a whole different thing.
Yeah,
are they?
That's something we probably shouldn't talk about in this podcast.
Yeah, that's going to be edited out right now.
Thanks.
Okay, so TEAS, right?
Now I've got a good gauge of our future relationship and all these
Exactly
trade
right.
shows.
At least could be 75% serious and 25% just silliness. Like that's the usual balance. Yeah.
I'm about the opposite, but
Okay.
we'll see how that goes.
Well, when
see
we're
how we
talking
can
about
change that
IP, that's
Yeah.
my equation.
Yeah, yeah.
If it's anything else, then it's probably opposite.
Good. All right, so where am I at? So I've been,
Well, I'll
Yeah.
recontextualize it
Yeah.
for you. So basically, situation is that you can't protect a name that's descriptive
Right, okay.
or generic. But essentially, it's like you can't protect red licorice because it's describing what the product is.
yes.
But certain trademarks can acquire distinctiveness over time that people think of a specific company when they're thinking of it. Something like General Motors, right? It's like people know if it is a particular car company.
Yep.
If you can show that, then you can sometimes get protection for a descriptive mark.
Yes. So that's actually what
yeah.
I had to do.
Yes, exactly. And there's, you would often consider those terms. It's like I would have the expectation in filing, say, Danan Enterprises, Inc., that, first of all, I would never include the Inc. There's just there's no point to that.
Okay.
Maybe Danan Enterprises.
Okay.
But it's like, think about what is the mark that people see when they see your product.
Yeah.
Do they see Danan Enterprises, Inc., or do they see, like, maybe on the box it says Danan Enterprises, or maybe it just says Danan?
Yeah.
It's how do you present it to the public, and that's the mark you want to go for.
Yeah.
And in general, though, some of those terms could be like throwaway terms, like enterprises. Like it's very likely that they'll say, well, enterprises is just a descriptive term.
Yeah.
You need to disclaim that. And then all you're doing is you're telling the trademark office and you're telling the world that we're not claiming the word enterprises outside of, in combination with the overall mark of
Yep.
Danan Enterprises.
Yeah, okay, great.
So it's a disclaimer. So
Yeah.
it's pretty much expected. If I filed a mark like that, I would expect to have to disclaim that. And it's really, it's no big deal.
Cool. For you.
But the, yes,
For you.
well,
For you.
I'm saying it's no big deal in terms of the impact of it. Like like the impact on your rights. It's
Yeah.
not a big deal.
Yeah.
So that's kind of how that works. But in general, what you want to do, again, is you want to pick a name that is distinctive, not descriptive. Something that, that kind of creates more of a unique branding that people might associate with your company and your company only.
Right.
So like financial services, like that's generic. That's
Yes.
not going to get you very far.
Yes.
But if it's like I'm looking across the room, I see a cooler, like Yeti Financial Services, like then maybe you have something, there's a distinctive term.
Right.
Okay? And
Yeti Financial Services. I'm just trying to think of how awesome that could be.
yeah. But there's another rabbit hole to go down there too. So the thing is, anytime you have a mark, it can be confusingly similar to another mark.
Right.
Okay.
Where people might think you're affiliated with the other company.
Now-
ordinarily,
Okay.
let me just finish
Yeah,
my thought
yeah.
on this because I think I know your question.
Yeah.
So, like ordinarily, trademarks are divided according to the product or service. So it's like if you have a name that's in use in a very different field, that's not going to bar you from using it in your field.
That explains another part of the process that
Yeah.
I had some confusion on. Okay.
Got it. Okay, cool. And so then normally you could have Yeti coolers and then Yeti Financial Services without conflict. The only issue is like when it becomes a really famous name, then it
So it'd
starts
be like
to blur.
Nike Financial Services. You're gonna
Right,
run
there's
into
no
an
way.
issue.
Yeah, no way you can do that. So things like very famous brands, the lines blur because people, when they hear that name, they're already thinking of one company.
Yeah.
And chances are they'll think, oh, they must have gone into the financial
Another
services
area.
business.
Yeah.
So it's, and some of it has been taken really far, like McDonald's, extremely famous trademark. If you wanted to open a shoe company and call it McShoes, they'll shut you down.
Really?
Yeah, basically like McAnything.
What about McCafe?
A McCafe is probably...
It's probably a trademark
They've
cup.
already got that one.
Right, right, but it's like McAfee, right?
Yeah.
McAfee.
Yeah.
So-
Okay. Interesting.
Huh. Okay.
But that's, when you have someone that's as big as McDonald's, like they have
Right.
the money to make the issue. And
Yeah.
one of the things about a trademark is it's up to you to police your brand.
Right.
You have to maintain the strength of the brand by going after people that tend to step on that. Otherwise, you risk losing it.
Yes, that makes sense. So I just wanted to have you clarify one thing in that there are two, well, maybe there are more than two, but per my knowledge, there are two types of trademarks. A word trademark and a mark, like an actual...
Like a design mark or logo mark. Yes, absolutely.
Yeah.
So in trademark application, you can go for the word itself, like Danan or Danan Enterprises, in association with a certain type of product or service that
which
you
is
offer.
what I did.
Right. And that's the word mark. And by the way, for Amazon, that's what you want.
Yes.
If they want to, if you want the ability to stop other people from using that name, you want a word mark. A logo mark is in combination with some type of design, some fancy font or some symbol, like that logo can be protected.
Yes.
Usually the angle of attack is to go for the word mark first and the logo mark second.
Okay, well that's actually, at least I did that right, because I knew I wanted the word mark first, because the only stuff, only products that I'd produced had the words on there. I did not have a logo at that time. So I'm glad I at least did that right, even though it took 14 months.
Yeah, well, no, that's great. That's great, and absolutely. And look, and here's the thing with trademarks, is you had kind of a long, meandering road to get your trademark because you did it yourself.
Did you get your trademark?
I did.
Okay.
I got granted my
Okay,
trademark. It wasn't meandering like he said. It was more like...
Lost in a forest or, stumbling through the sea.
Yeah, so
Right, you didn't encounter any trolls or any mythical beings.
No,
you know.
they'd be in stone if I had, but anyhow.
Right.
What I had was I would need to take an action, right? Get a partial denial, need to take an action, start looking up to it, say, screw this. I've got another 30 days before I have to put in a reply.
Right.
Run it down to the wire and then go really hard on the research, finding the pages, which isn't all that convenient.
It's not.
I had to contact the attorney, the patent attorney, the USPTO,
the trademark examining attorney.
Yes, that guy. Multiple times saying, "This is what I am going to reply. Am I doing this correctly?" And you say like, "Oh well, no. You need to do this thing." I'm like, okay, now I need to go onto Google and search for that term, and to be able to take the right action.
And so then, first of all, that takes up a lot of your time.
Yeah.
And then also, you could easily get it wrong because a lot of times trademarks, it's highly nuanced, and it's kind of like, at this point, I know it when I see it.
Yeah.
And it's kind of like, sometimes all the research could be explaining how to do this thing, but then the answer is actually, no, don't even do that thing, do something else.
Yeah, I can't.
It's like, okay, skip this, or this is the reason to redirect and change directions, not just learning how to answer this thing, but it's like, you might need to pivot.
Yep, that's precisely what I ran into doing it myself. I'd go down a rabbit hole and go, oh, he said I don't even need this.
That didn't work.
Yeah, that was useless information that I'll just trash out of my mind.
Right.
So let me ask you a question. How long, and I realize that this is highly dependent upon who's contacting you, but what would be a good average time to where someone comes to you and then you come back to them and say, it's been approved and now it's going to go into the Gazette? The Gazette being the
Gazette being
the official Gazette, where they publish your trademark.
Thank you.
Once your trademark is approved, it gets published for opposition.
Yep.
So then there's a 30-day period where other people can then say, well, wait a second, this shouldn't be registered because it conflicts with my rights.
Yep.
So it's called publishing for opposition.
I don't even know why I keep trying to explain these things.
No, it's okay. You have enough information to invoke the explanation.
The correct
that's all that
information,
matters here, right?
He's like, I know there's a term
I know
there.
I know what you're getting at.
Yeah.
Yes. So it varies. I mean, the trademark office has gotten very busy recently, so it's a bit longer. And I'd say
let's take that part out of the equation, because busyness. Okay, that's not necessarily your factor. because that's how busy they are, not necessarily
Right.
how much knowledge you have in order to do the right things.
Right.
So what's the time involvement on your end? And then we can just kind of tack on the fact that it's 3 months after you've been published in the Gazette or whatever it is, and the time involved when you're waiting for a reply.
Okay. Yeah, I mean, well, typically, first of all, like a client comes to us, first thing we want to do is a trademark evaluation, do a deep dive
Sure.
to see what they might be in conflict with. And then we'd advise what applications we should be filing. Usually within 2 or 3 weeks, we get all of that done and get it filed. Then it's a good amount of waiting for the trademark office. It's more now than it was before. Going back just a year ago, it was maybe 3 or 4 months to have it reviewed by the trademark office,
Yeah, that's
and
about
then to come to you.
what I-
Now it's getting closer to 10 months
Oh, wow.
to have them review it.
Okay.
They are backed up. There's a lot of people filing trademarks. The rumor is unsubstantiated. I haven't seen stats, but a lot of Chinese sellers are filing lots of trademark applications.
Wonder why that could be happening.
Yeah,
We
you
haven't
know.
seen
Strange.
anything that would go along with
Yeah,
that.
no, that seems inconsistent with
That
everything that we
completely
know
is
about
consistent, yeah.
how,
I'm just
you know,
gonna go ahead
how,
and cancel
how
that.
Chinese
On
operate on Amazon.
Not at
No, not at all. It's a
Fallacy.
A myth. Old wives' tale.
I'm gonna call you on that one.
Okay. Yeah. Come on, Rich. I thought you were going to come down here and tell us the truth about this.
Yeah,
You know? But yeah, so it's gotten to be a longer period of time.
Cool. So
But,
then,
well, what I see in all this anyway, it's like if you're doing your own trademark, it's possible to get through the process like you did. You got
Yeah.
through the process.
yeah.
A lot of people are successful in getting through the process, but is it worth it? The thing
No.
with trademark, okay.
It is not worth it. It is not worth it.
Yeah, exactly. And the thing with trademarks is that it's highly nuanced.
Yeah.
Whereas like a little steer of direction can make a big difference. And like I would not have applied for it with the ink. You'd be better off with Danan Enterprises as the mark itself, for example. Just little things that make a difference. It's not probably going to make a big difference in the long run, but it's
Yeah.
just, there are these little nuanced things that make a difference. Or when we get a response from the trademark office knowing which direction to go.
Yeah.
So it's like if there's value at stake. If the thing that you're filing matters to your business, it pays to have it done well, have
Okay.
it done right.
So then would you say that it's, just to kind of round out the question so I can do my comparison with me, a few weeks' time in your case of like, in order to have all of your ducks in a row for presentation?
A few weeks to get everything together and get it filed, yep.
Okay, so a few weeks and 14 months for me. And that's when the USPTO had a lot less going on,
Right.
a lot less going
Right.
on than they do now. So how much, here's the question for everybody. How much is your time worth? Multiply that by, I'm just going to estimate I spent 30 hours researching, maybe even more, but at least that much
sure
researching
you did
stuff.
more.
I'm sure I did more as well. Maybe I shouldn't even be.
Just with the amount of time that we spent talking about it.
Yeah.
Yeah.
Okay, so let's call it a full work week, 40 hours that you spent on this, right? What's your time worth? Multiply by your estimated value, or if you haven't gotten it figured out, but I guarantee you you're worth hundreds of dollars an hour. And throw that idea into your bin of awful ideas and just go see Rich.
Yeah. And also, what's it worth just to know that you've got it handled?
Correctly.
So that you can
Yes.
focus your
Correctly.
attention on the other
Yeah. Oh, that's
things
another
in
thing.
your business.
Yeah. Yeah. It's like
Yeah.
it's like wondering where your child is.
Right.
You know, it's like it's in your house. Your child is in the house with you, but like, why is it quiet? Where did that
That's
child
always
go?
terrifying, isn't it?
Yeah,
Right.
exactly.
Yeah. It's
Yeah.
like, oh.
Clearly, your iPad's in the
Yeah.
toilet right now.
Yes.
Not a true story. Maybe.
So yeah. So then the question the question I have for you, the audience, is, I'm going to lean in here.
Ooh.
What's your time worth?
Exactly.
Anyway.
Goldstein Patent Law. All right. Cool. Well.
Yeah, and I had a very different type of situation much earlier on the line. So we were looking for a product in the fitness space. And I went on to USPTO, did a ton of searches, came up totally empty-handed, meaning didn't find anything that I figured would be a problem. And we're talking, between me and my business partner, we probably went through a couple thousand patents. Just scanning to make sure we weren't actually, because we knew that there was another major player on that particular
But the question is, you're scanning them, you said to make sure that we weren't, but how do you even know when you're in conflict?
Well, yeah, so, and that's really where, here, I'll cut to the moral of the story.
Yeah.
Or let's cut to the punchline where it went all wrong, at least early enough that we didn't, really get into trouble. But basically, we were about to order from our manufacturer, probably $10,000 to $15,000 worth of, a first inventory order. And I happened to call up a buddy that's in the Amazon space who I've gone to before for coaching, and I mentioned the product, and he got really wide-eyed. And he goes, you should talk to so-and-so, because he did that and got shut down by that said company. So this is just an interesting thing that I'm sure a ton of Amazon prospective sellers or sellers who are diving into another product are, is it something you can do on your own to make sure you're not stepping on someone else's toes?
Absolutely not. I said absolutely not. Why did I have to say absolutely?
Yeah.
If I had a little exception to it, I probably shouldn't have said absolutely. But I would say
unequivocally no.
Possibly not.
Absolutely. Well, okay, so here's the thing, because I have one hack, or one possible cheat that there is that's possible. So yeah, absolutely not in terms of being able to go through the patents and search to see for if there's an existing patent that might be a conflict.
Okay.
But there is a workaround. The workaround is that U.S. patents expire, and once they expire, they're fair game.
Isn't it 99 years or something like that?
No, that's
No.
a Jay-Z song.
Oh, okay.
Okay.
Yeah, 99 years, but
A
more
patent
time
name
ain't one.
Yeah, exactly. No, it's
If I had a hat, I would take my hat off for that reference. That was good.
thank
that
you.
was very well done.
Thank you. Pop culture references are my specialty.
It's a very good specialty.
There is a game between my friends. Is will Danan know this pop culture reference? I typically
And you're
don't.
bad at it? Okay, you're bad
I'm
at it.
good at not knowing.
Oh, okay,
yeah.
okay, yeah.
Okay, so yes, so now to the serious
But it's a
answer to
much
the question.
shorter amount of years than
No, 20 years
Yeah.
from filing, essentially. 20 years from when the application was filed. And so the shortcut is that, like, if it's a very simple idea, like, can you hand me that screwdriver that's right there? So, like, you've got this, you've got a flathead screwdriver, very, very basic design, very basic configuration. If you could find a patent that's expired, let's say a patent from 25 years ago that has this exact shape, that it's this exact invention,
Right,
then
okay.
you know that patent has to be expired.
Right.
And then therefore if you want to make anything, if you want to make something exactly like was shown in an expired patent, then you're free to do so. So it's kind of a little bit of a workaround but this doesn't apply to more recent products. This applies to something
20 years older.
Yeah, like
or
something
older.
that's kind of like a staple type product, like, a paperclip. Can I make a paperclip?
Sure.
A paperclip? Well, yeah, if you make it just like it was, just like it existed 25 years ago, 30 years ago. And by the way, it doesn't even need to be a patent. It could be something that was out there in public 25 years ago, 30 years ago. You
It
see
just
an
has
old.
to originate that long ago.
It has to have been out in public that long ago. The
Okay.
reason is this. So it's a little bit of additional logic to it, and that is that the rule for at least a century has been that once you come up with an idea, once you put it out there in public, if you haven't applied for a patent within 1 year, then it's too late.
Hence patent pending.
Jeez.
Yeah, so that's something that most entrepreneurs don't know. You need to apply for a patent. Generally, you should do it before you make it public, but in the U.S., there's still a grace period that if you've applied within 1 year, then you're okay. Can I hold on to the screwdriver for one more moment, or do you need it? Do you need
I
it?
don't need it, it's
You
fine. You
feel
can have it.
lost without your screwdriver?
I thought maybe you were just
He
done
keeps it with
it.
him on
Right,
his podcast.
right. No, but I'm making my point, and it's sharp. This is a sharp point. So then the reason I could say that then about it being out in public is, imagine there was a product out there 25 years ago. It was out there in public. Worst case, they had to apply for a patent 24 years ago, in which case the patent would be expired.
Expired at this point.
So whether or not they ever applied for a patent, if it's out there 25 years ago, then you're safe in knowing that you could make exactly that. The thing you need to be careful about is this, though. It's like you want to make this product exactly as it was described 25 years ago, you're free to do so. But maybe the current manufacturer has used some type of new materials. It may be possible that there's a patent on some combination of materials, or maybe they've improved it and they've added another little latch over here that lets you ratchet it.
On it.
Yeah.
Yeah.
There's something. You're not free to do that. You're free to do exactly what was in the patent, that dates back to there, or exactly what was on the market
Now,
25 years ago.
Why are you not free to do that if you're taking something that's patented and then making a change to it?
Well, a lot of patents are for an improvement on something that existed.
Right.
Okay,
So it's possible there could be a patent on it. It's not likely that there's going to be a patent on the different rubber materials or whatever, but you're not totally in the safe harbor like you would be.
Yeah, unless it's
it.
especially we're talking tools, it could be an anti-fatiguing handle. Some
Exactly.
crazy, yeah.
And I will pass the talking stick back to you.
Thank you.
You now have the baton.
So I think that kind of brings us to our next question.
Well,
You have
yeah,
one?
the thing on that also is that, so then the question becomes, because here, let's look at the world that so anyone who's coming into Amazon, for instance, a lot of what these guys are doing is finding some product out there and going, how can I tweak this just ever so slightly so it's a little better than my competition? At that point, I guess, to your point, you're potentially diving right into someone else's patent then.
Yeah, exactly. So here's the thing, and this is a really common misconception about patents, is people think okay, if I got a patent, that means I'm not infringing anyone else's patent. It's not true. You could have a patent and still be infringing. I mean, it seems logical though, right? It's like, hey, if I'm different enough to get a patent, that must be I'm different enough to not infringe.
I would think so, yeah.
But kind of the way it works, I'm just going to grab the screwdriver back again.
Talking stick.
The talking stick / screwdriver. So
Talking tool.
So yeah, no one can say a word while I'm holding this. It is the talking stick. But basically, yes. Thank you. I'm from New York, so I get that. So it's like, imagine that one person has a patent on the screwdriver. It's got this handle, and then it's got a shank with a flattened end. Mm-hmm. Let's say they have the patent on that, and then you come along and you say, yeah, but I could add this ratchet mechanism in here. To allow it to ratchet, you can get a patent on your improvement, but you can't make a screwdriver without it having a handle and a shank with a flattened end. So you would need to license from the person who has the screwdriver.
The other aspects of the screwdriver.
If that patent was still in effect.
Right.
Often the way it goes is like you're building on, it's called prior art, things that came before you. Often you're building on prior art that might be 50 years old. And so it's not like anyone has a patent on the basic idea of the screwdriver, but
any longer.
But that's
Mona
how
Lisa
that
with a mustache.
Right. Well, that's copyright. Let's not go there. In either sense. But yeah. So that's kind of how that works. So if you see an existing product, you say, well, I'm just going to tweak it. You're not necessarily going to be out of trouble with regard to
right. Okay, that makes sense.
Yeah,
now.
from my understanding, isn't it you have to be at least 25% different or something like that? I'm sure even that maybe.
I think that's on copy.
Well, here's the thing.
We've gotten
first, no. And
definitely not.
But you're in good company.
Okay.
Because
good.
a lot of people think that. Because how do you make something 25% different?
How do you
if I don't have a handle, is that 25% different? You can't quantify it.
Right.
The way it works with utility patents is what protects the functionality of an invention, is through what's called the patent claims at the end of the patent. It defines the critical combination of what's necessary to infringe. So it could be like basically a hand tool having a handle, the handle having a flattened end, and then having a shank that extends into that handle with a flattened opposite end, something like that. That definition, that's what would make infringement. And that's why you guys looking through the patent record trying to see, well, are we infringing? You need to know how to interpret patents to determine that.
I was just going to say, not only so I've seen that, right? And not only do I hate reading that,
Yeah.
I'd also be hate to be the guy that has to describe that.
That's me.
I know it is. I'd hate to be you. No, I would hate.
It's not easy being me.
He's
I
actually
tell
totally
you.
really okay with you
It's
hitting
not
that.
easy.
I feel like that's
why he
another
has a
song
living.
reference.
Right.
But not having your knowledge in this area, like if it were just, again, I did my own trademark, I would hate to have to describe my own patent.
Oh, I'm sure a patent is also whole nother league.
I would, yeah, I
From a
would.
trademark.
First of all, I
Oh
wouldn't
yeah,
even go
yeah, yeah.
into
No, a
it.
whole nother league. Here's the hierarchy of it all. I would say when it comes to a copyright, which is for content, you can do your own copyright application. You don't
Okay.
need me for that.
Okay.
Trademark
But
application.
someone could use you, yes?
They could use me,
Okay,
yes.
good.
And actually for some sellers, I do a lot of bulk copyrights because there's a lot of value. That's another story. But trademarks, it's possible to do on your own. It's like if you're launching something out of your garage and you're just like, this is not going to be big, it's just a hobby thing, maybe do your own trademark. It's okay.
Yeah.
You'll
And
probably
still,
be okay.
still a pain in the ass.
Patents absolutely can't be done on your own.
Yep.
And it absolutely matters who you work with. Like there are people
Okay,
that
that
do
makes
a
sense.
crappy job for patents that call themselves, these son of a bitches call themselves patent attorneys. I'm thinking of Glengarry Glen Ross. It's like, you son of a bitches call yourself salespeople? No, but, like there are, there's a lot of really bad patents out there too.
Yep.
Here's the thing about patents, is it's possible to protect a broad invention, like that covers a new concept, if it's written correctly. But a lot of patents end up being very narrow, very specific, and they cover details that just don't matter.
Yeah, okay.
You know?
Right, which kind of bottle you into one particular thing.
Yeah, because then if someone else is not copying that feature, then they're not infringing.
Right, that makes sense.
Cool. Well, we have one more subject, and I think we are about in need to wrap this up.
Okay.
I'd like to ask you about intellectual property, how it concerns an Amazon seller, and or does it? Does it concern Amazon sellers, and how?
Okay, yeah. No, sometimes it does and sometimes it doesn't.
Okay.
Right? I mean, if you're selling blankets generically, right, with no particular brand name, then it doesn't.
Kind of what I do.
We don't know anyone who does
Right,
that at
no.
all. That's a
Then
totally,
then it probably doesn't concern you. Like you're just selling a generic product
Yeah.
and white labeling, whatever. Like, but first of all, if you have something that's unique, something that the product really is distinct, and you think people are going to start copying that uniqueness, then you might want to look into it whether it's possible to patent it. Not every type of uniqueness can be patented, but it often pays to look into it because, a lot of times with white label products, it's a race to the bottom through pay-per-click and other things.
Right, yep.
absolutely.
And so everyone looks to differentiate their product.
Yep.
If you actually differentiate the product itself, you might want to look at the possibility of protecting it. And then if you do that, just super quick on that, there's utility patents and design patents. Utility patents is more conceptual, more about the structure that makes it function. Design patent is about the way it looks. Traditionally, people would say design patents aren't worthwhile because you change the way it looks, you get around it. But you know how people copy you on Amazon. They don't get imaginative.
They copy to the
They don't-
absolute detail.
Exactly. They don't say, wow, that's a cool concept, let's design our own.
They'll
They
do the
just
same color.
They just take yours exactly, and
Yeah.
therefore it would infringe on
A design patent.
the design patent.
Right.
The other thing too is because utility patents are all about wording and definitions, it's difficult to enforce on Amazon. There's more involved procedures.
Yep.
Whereas design patent, if you've got a design patent that looks like the product, you do an IP complaint through your seller account, and you say, this is my design patent number. They'll look at the pictures, and they'll shut them down. So,
Interesting.
Seller Central people, whoever, they'll look at the picture. They'll say, oh yeah, that looks the same. They'll shut them down.
Right.
So design patent could be very effective
Okay.
for preventing people from jumping on your listing, for jumping on your product.
All right.
That's one.
Now
Two,
we're going into the definitions of intellectual property, correct?
there's some definitions in here, but really what I'm trying to do is say what's the point of like when does IP matter for Amazon?
Okay.
So number one is protection.
Yep.
It's like protection of the product when it's possible through utility or design. So now number two is going to be your brand. You have branding that you use. You should get that trademarked, and then you go for brand registry.
God,
So
not
that's
even,
number
not
two.
even just to mention, just for the purpose of being able to get those added features, added advertising, added A+ content,
Yeah, of course.
all of that
Yeah,
stuff
all
makes
the
it
extra, yeah. Absolutely.
worthwhile alone for
Yes,
that reason.
definitely.
Exactly. And then the third and final reason why IP matters to Amazon sellers is that you could end up stepping on someone else's toes. Is
Right.
that like I'm dealing with more and more situations where someone gets shut down because of someone else's patent.
Yep.
So it pays to know a bit about IP so that you could make good decisions about when to patent something.
Cool.
I could give you a resource for that if you like.
What's the resource's name? Rich
well-
Goldstein?
Well, no. I mean, it's a more top of the funnel
Okay,
resource
okay.
than yeah.
In this room kind of reason.
Right. It's my book.
Got it.
So I wrote a book for the American Bar Association. They asked me to write a book to explain to entrepreneurs how patents work. It's called the ABA Consumer Guide to Obtaining a Patent.
Okay.
And
Where can we find it?
That is one sexy name, by the way.
ABA, this is patent.
Yeah, that's a big credibility feather in my cap, that's for sure.
Yeah.
But by Rich Goldstein. I mean, you could find it on Amazon, but I'll send the copy to anyone in your audience who'd like.
Oh, that's
like
awesome.
one.
Thank you.
That's awesome.
And all they have
So
to
guys,
do.
make sure to just comment in the. Actually, they should
Yeah,
probably.
they need to
message
reach
us.
out.
I'll tell you exactly how to do it. It's just real simple.
Okay.
You send the message to my assistant. It's assist, ASSIST, at goldsteinpc.com, and include your name, mailing address, because it's a physical book, and your phone number, because you can't send anything on Amazon without a phone number.
for tracking.
So
Yeah.
name, mailing address, phone number to assist
Social
at
Security,
Goldstein.
because we need that
Oh
for
my God,
tracking.
no.
Yeah, no, and I don't even put you in a funnel
He's
or anything. Like you're not even going to get like follow-up emails or anything. It's just I'm passionate about educating people about
Yeah.
this stuff, and I'm happy to educate anyone who really wants to learn.
Yeah,
That's awesome.
we know people personally that have literally lost their business from errors in this area.
Yeah.
Definitely,
So
yes.
It's a very
absolutely.
important point.
Or products at the best case scenario, just a product.
Yeah.
Right.
I have friends that have had that happen too, and they, it's not until you've ramped up that somebody notices you. You know what I mean?
Yeah.
Like you're not noticed until you're making money, and then suddenly you can no longer make that money. So, better to have your ducks in a row first
Yep.
than second.
Right, because
Third.
you don't want to play second duck to the first fiddle or something
Yeah.
like that. I don't know.
Toot.
Some
Remember,
expression.
I almost went somewhere I
Is that
shouldn't
a
have.
Jay-Z song?
It could be. It could
Second
be.
duck to the first fiddle.
Yeah.
All
Oh God.
Yeah.
right, awesome. So, and then just one last kind of parting thing. Could you give us a simple definition of what is intellectual property? What is
Okay,
the
yeah.
definition of that word?
Intellectual property is property of the mind. So intellectual property is, they call it intangible property because it's about ideas. It's the overall category of the law that deals with protection of ideas, and it includes patents, trademarks, copyrights, something called trade secrets, rights of publicity, things like that. So it's a big umbrella
Yeah,
for,
it's
for
the
that area of the
encompassing
law
term
that
for-
deals with intangible property,
Got it.
intellectual property.
Awesome. Thank you very
IP.
much.
Yeah, you're welcome. And one last thing I'd say though too about the book is that if you do that, mention the show so that I know, because I extended
Oh,
the
to
offer
send it.
here.
Yeah.
And then also so that this way I could either turn around and tell these guys like, hey, you guys have a lot of listeners. They're really inquiring. Well, you know what? I didn't get a single person ask me about that book. So definitely mention the show when you send the email to assist
Yes.
at goldsteinpc.com.
Well, awesome. I think that's a good place to stop for now, and then we'll dive in more later. So with that, guys, make sure to like, subscribe. You're probably either seeing this on YouTube or Facebook, so share, because there's a lot of misinformation, not intentional, I would say misinformation, but just wrong information when it comes to this area out there. Some of the things that I was talking about come from a major course.
Yeah, well, that's why we like to go to the authority on the subject that we're discussing.
Ooh, man, that makes it sound
And
very
then,
official.
And the next best thing is to ask me.
You are the authority on the subject.
Thank you so much for tuning in. Next time we'll not include Danan so that we can go much faster. But other than that, no, just kidding. Thank you guys. We'll catch you in the next podcast. Adios.
Thanks for listening to Innovations and Breakthroughs with your host, Rich Goldstein. Be sure to click subscribe, check us out on the web at innovationsandbreakthroughs.com, and we'll see you next time.